St. Mary's Law School, clerked for Judge McCormick, was it not, on the Court of Criminal Appeals. For how many years were you with Judge McCormick?
1 year with him and 4 with WC.
4 with WC Davis on the Court of Criminal Appeals, and has been in the county attorney's office about 4 years now, and has come up and done this before, and has done many more hours in his prosecution practice. For the defense, we have in this corner, Michelle Maple or Maples?
Maples.
Maples. I always want to call Michelle has been married, what, about 6 months now?
10 months.
Okay. Changed her name to everybody else for a while. One of the young lawyers who came to the courthouse, and we see a lot of young lawyers come and go, and some of them stay, the good ones, and start making a real go of it. Michelle has been one of those. She's tried several lawsuits and just recently tried a sexual assault of a child in district court and walked out with a not guilty. So obviously she's doing something right. So we thought we could get her down here to see what she's doing in the way of voir dire. What they'll do is about 20 minutes each, or just a portion of their voir dires, give you a sense of what they do with jury panels, and then we'll stop, let them kind of talk a little bit about what their philosophies are, what they're trying to accomplish, and why they're doing it the way they're doing it, and then we'll let you ask them questions. So I'm going to get some stuff up here in this judge's place, but you can go ahead and begin the stage voir dire in this DWI case.
Thank you, Your Honor. Counsel. Lady and gentlemen of the jury, my name is John Lipscombe, and I do represent the state of Texas and the people of Travis County in this cause. You'll have to excuse me. I seem to either be very clumsy or something happened to my foot. Actually, it happened in Capital 10,000. I just come up to Governor Bush, and I was about to pass the guy, and he reaches out and he trips me. And you may not believe this, but it just goes to show you can't trust a politician not to trip a working man who's trying to get ahead. What we're here today for right now is we're going through the system we call the jury system. We went through a jury panel and paneling down at the Coliseum. You had to sit there for an hour or two. Now you're on the panel, and we're going to decide who we pick or don't choose for a jury. And some people have some misconceptions about that. We don't actually pick a jury. What we do is, after the jury panel, I get my chance, and Ms. Maples gets her chance to talk with you, then we actually strike people off the jury panel. So it's not a matter of us picking you, it's a matter of us striking names. Sometimes we use some strikes and sometimes we don't. But during this voir dire process, what we're trying to do is just find out your likes and your dislikes. First up, my first rule is there are no right or wrong answers. Every individual, according to our Constitution, has a right to his or her own feelings and his or her own beliefs. I certainly do, Ms. Maples does, the judge does, and so do you all. Therefore, what we're trying to find out is how you feel about certain aspects of the law. For instance, the case that some of you will hear today is a case concerning DWI, or driving while intoxicated. Now, anybody was surprised by that? We have a whole lot of those cases in misdemeanor court, don't we? All right. Is there anyone here, can you first tell me, is there anyone here that knows what the driving while intoxicated law says in Texas? Just raise up your hand. Does everyone know that it's illegal to drive while you're intoxicated? Okay? It's not illegal to drink something and then to drive. But it's illegal to drink enough that when you do get behind the wheel, that you are intoxicated. What the state has to prove are certain elements of the case. We have to prove that a certain individual, in this case a defendant, in Travis County, Texas, because you need to prosecute someone where the offense occurred, on or about a certain date. We have to be specific when it comes to the date, okay? Or fairly specific. We have some parameters. That person did drive a motor vehicle, okay, while the person was intoxicated. The intoxication under the law has a couple of different meanings. You can prove the intoxication by one of three ways. Number one, you all heard about the breathalyzer, the breath machine, the intoxilizer machine. Y'all heard about that? Okay. I believe it's Mr. Burleson.
Yes.
What have you heard about the intoxilizer?
Measures how much alcohol is in the breath.
Okay. And do you know what is a presumption of intoxication in Texas? Have you heard about that?
It's 0.1%.
0.10? 0.10 would be that. That's right. Okay. Has everyone else heard about that? Okay. Has anyone here had anybody that has been involved, any relatives or friends that have been involved in a DWI accident? Anybody? Okay. How about you? Is it Miss Ford?
Yes.
Miss Ford, have you ever been driving down the road and you look at a car ahead of you, or maybe one coming towards you, and the car is driving erratically, and you wonder to yourself, I wonder if that driver has been drinking?
Oh, I think that all the time.
Okay. On about 2 o'clock in the morning? if you
Well, I'm
happen to
usually
go
not
out
out that
anymore-
late.
Me neither. I don't do that anymore. I can't go out that late because I don't want to see those type of people. Okay. What things do you look for, Miss Ford?
Oh, when I think somebody may, well, people seem to be driving so fast these days anyway, and so, you know, I see these cars just cruising by me, especially with these young people in these cars, and it makes me kind of wonder what's going on. You know, I know there's a lot of young people out drinking, and 6th Street just around the corner and stuff. You know, I get concerned.
So you worry about if the car's not being driven in the correct manner,
Right.
okay? Would you agree with me that not every person that's intoxicated that's driving does the same thing? They don't all weave a certain way. They don't all turn a wide corner.
Oh, I agree.
They don't all run a stop sign. There can be different indications to look for, right?
Right.
Okay. Mr. Bird, is it? Mr. Bird, you're a business person. You travel quite a bit.
Yes, I do.
Okay. And have you seen any indications when you've been traveling down the road, maybe someone you might think is intoxicated?
Oh, yeah.
What do you see?
Shifting speeds over, wide range, if it's on a highway, all the way from 30 up to 70, and weaving, and not, if you come up behind them and they won't move out of the way, just things like that.
Sometimes they can be acting in an obstinate manner, can't they? Or sometimes driving too slow. Not everybody drives the same way when they're intoxicated, do they? Is it Mr. Daly? Mr. Daly, it says down here that you're a medical aid and a farmer.
Yes.
Have you ever, as a medical aid, have you ever treated someone who's intoxicated and been in an automobile accident?
Well, most of my work's tri-state schools, so I don't do so much dealing with that kind of accident. I don't deal with real accidents, you know.
Okay, have you dealt with anyone who's intoxicated out there, but hasn't been driving, just, might be walking around intoxicated?
See it a little bit, not all too often.
Okay, how about your friends, or when you were in college, or
No, not too many people I spent time with drink very often.
okay, when you're in nursing school, did you ever run across anybody at one of your parties, maybe the last one, and you saw certain indications that made you think that person was intoxicated?
Well, I'm not much the party type. I don't make those too often. I guess I have seen some people drinking too much.
What turned that little clock in your mind? What made you think the person might have some problems or some, what we call impairment?
I mean, pretty much you start drinking and you start losing control. It's going to happen.
Okay, what might a person be doing when they're drinking? Just say a little bit. Okay, they just start losing control. They're not dead drunk.
I mean, really, as soon as you start drinking, any kind of fool thing can happen after that. People start getting loud and obnoxious and generally unpleasant to be around.
Okay. The second way that you can prove intoxication, then, as you all have been talking about in another way, is a loss of your physical faculties. And a third way, which is connected with that, would be a loss of your mental faculties. We talked about this way, you start talking real loud. Or maybe you start talking real soft. Or maybe you notice someone and they don't have a bad foot because they weren't tripped by the governor, and they're walking like this. They're holding on to the car. You ever see anybody stop on the side of the road and doing the field sobriety test? Have y'all ever done the field sobriety test for fun or anything? Loss of mental or physical faculties, the things that you look for. If you think of DWI as a long continuum, look at this bench in front of you. On this end you have stone cold sober. All right, sober as the judge. On this end you have dead, falling down, staggering, puking up, drunk. All right. Neither one of those is the law. The law says driving while intoxicated. Intoxicated, loss of normal mental or physical faculties, presumption of which you may have a .10 or higher, is somewhere in between. Okay? So we're not talking about someone having broken the law in the state of Texas that is staggering out, fully mush mouth, can't talk, can't do nothing, know how. We're talking about someone who has lost their motor skills or their mental skills to the point that you can see an impairment. And the legislature has decided that we're going to hold that person responsible for the offense of driving while intoxicated. And why should we hold that person responsible, Mr. Burke?
To create a danger to everyone on the roads.
Okay. DWI drivers can cause deaths, serious bodily injury. Has anyone on the panel had a loved one or a good friend that's been hurt by drunken driving? Or have you known of someone who's been hurt by drunken driving? Okay. You've read the stories about it. You can see that those things can happen. It's not often a mythological world, it's real, is it? Okay. The state doesn't have to prove that that person is fallen down. The state only has to show that the person has lost some of the normal use of their faculties. In order to do that, the state would bring the evidence, wouldn't it? The state's entitled to depend upon the testimony of a single officer. And why do you think that is? I'll pick on you, Mr. Bell.
Well, if the officer's the only one there, then that's the only one that can prove it.
That's right. Usually officers don't carry, sometimes they carry riders, but usually we don't have 2 or 3 witnesses in tow, right? Some officers may have video cameras in the cars, but because of the cost of those, not all cars have them, right? Okay? And it is intoxication at the scene of the offense when he stopped, when the person's observed driving. It's not later on at the station. Okay? So we're entitled to hear and depend upon the testimony of one single person. Is there anyone on the jury panel that would have a problem with that would hold it against the state because even though we couldn't help it, all we had was the testimony of one officer? Is there anyone that just distrusts the testimony of cops so much that we're going to want somebody else? Okay. The jury will be the sole judge of the credibility of the witnesses. You all can decide to believe or disbelieve any witness, including the defendant, if he chooses not to testify. If he chooses to testify. You know, the defendant has certain rights in the trial. He has a right to a lawyer. He has that lawyer. He has a right to a trial by jury. He has the jury panel here seated before him. He has a right not to testify. Those are absolute rights that the defendant has. They can't be taken away from him, and I support them 100%. But if the defendant chooses to testify, then you don't have to give that testimony. The fact that he came up and is testifying, you don't have to give that special credence. I'm just asking you to judge each witness that you hear from in the same exact manner. And then if you believe someone, give their testimony credence. If you don't, you can disallow it. You can throw it out. Okay. Now, the last thing that I want to talk to you about very briefly is the state has the burden of showing that this person is guilty. As he stands here, he's not guilty. He's been charged with an offense, but we haven't proven it. And believe you me, we take that seriously. It's up to the state to prove all the elements that he was driving on a certain date in Travis County in a motor vehicle while intoxicated, meaning losing some of the physical or mental faculties. Those are the things we have to prove. We don't have to prove the color of the car. We don't have to prove the time of night. We don't have to prove the color of the shirt he was wearing. We have to prove those elements beyond a reasonable doubt. The court will give you a charge that some of you will take back into the jury room. And that court will define what beyond a reasonable doubt is or means to you. If you look at the same continuum, you have on this end, you have all sorts of doubt. Okay? ASD, all sorts of doubt. The other end, you have no doubt. There is no doubt in your mind. Why? Because you saw it. So if you saw it, you would be sitting here, you'd be witnesses, wouldn't you? Okay. And there are different burdens of proof along that continuum. In several cases, you might have proof by a greater preponderance of the evidence, a greater weight of the evidence. Somewhere further on here, on this side of the continuum, they're not reaching the end. You're going to have evidence beyond a reasonable doubt. And what that means, beyond a reasonable doubt, you look at the evidence, you look at the picture, you look at the pieces that we all give you, and you put them together. And it's a reasonable doubt if it's something that would make you hesitate to act in the most important of your personal affairs. Okay? You can give examples of buying a house, having a child, picking a good school. The most important of your personal affairs, it's important because the man's liberty is at stake. And we take that seriously. But it doesn't mean beyond all doubt. It doesn't mean that we have to disprove doubt about something that's not an element of the offense. Okay? It's beyond a reasonable doubt based upon your reason and your common sense. It's based upon your reason and common sense, putting the evidence together after you see it up here. Is there anyone on the jury panel that feels like they can't listen to the evidence and they can't judge this man who's sitting here based upon that standard? Okay. Does anybody have a question for me? I'd like to thank you for your time. This is something that I probably won't get to do as a lawyer. And so it's kind of exciting for me. I appreciate your time and your effort and appreciate you listening to me. Thank you.
Counsel for the defense.
May it please the court, Mr. Lipscombe. Ladies and gentlemen of the jury, my name is Michelle Maples and I represent Mr. Alderson's case today. Just got a few questions for you. Mr. Burton, when you first walked into the courtroom today, were you wondering what my client had done?
Yes.
You were? What was going through your mind?
I suppose, thought, I wondered what he'd done to get into trouble.
What had been charged with?
Yeah.
Ms. Bird, what about you? Were you thinking the same thing?
Yes, I guess I was. It's been kind of a busy day, kind of running around trying to do things I haven't given a whole lot of thought. But yeah, I was curious as to what you were doing.
Mr. Burleson, what were your thoughts when you first walked in today?
I don't know. Thought maybe it's a murder. Don't look like a murder.
What exactly does a murderer look like? No, don't answer that. Mr. Daly, did you have any thoughts regarding the characters who were sitting here at the council table when you walked in today?
He at least did something that got a police officer upset with him to have him brought in court like this and to go to all trouble to trial.
Okay. Let me explain to y'all that my client has been accused of driving while intoxicated. He has been charged by an information, which is a piece of paper that puts my client on notice of what he's been charged with. Okay? That piece of paper, the information, is not evidence against him. The mere fact that he's been charged with an offense isn't evidence against him. How do you feel about that, Mr. Burleson?
That makes sense to me.
Okay. So when you first got to the courtroom and wondering kind of what he did and why he's sitting there, does that change your mind any when I explained to you that the information is not any evidence against him?
Well, he's got to be here for some reason.
Okay. Why do you think he's here? Now that you know he's been charged with DWI.
That man over there said that he got pulled over. There was a police officer that saw him do something.
Okay. Ms. Ford.
Yes.
If you had to vote right now, guilty or not guilty, for Mr. Alvarez, how would you vote?
Well, right now I'd have to vote not guilty.
And why is that?
I don't even know what he's accused. I know he's accused of driving while intoxicated, but I don't know, what they saw or what he did or how he was driving, and so there's really no way I have to have a lot of doubt about whether or not he's out.
Okay. Mr. Burleson, how do you feel about that? How would you vote right now if you had to vote?
Well, I haven't seen the trial yet, so I couldn't vote, really.
Okay. Mr. Burke?
Nothing to vote on.
Mr. Bailey?
As I say, all we know is he did something that got an officer to think he deserved to be brought into court.
Okay. I think what y'all are all thinking about, even if you can't put your finger on it, is the presumption of innocence. All right, Mr. Alvarez sits here before you today, an innocent man, merely accused of something, but innocent unless proven guilty by the state beyond a reasonable doubt. Do any of you feel right now that Mr. Alvarez is not innocent? Do any of you have a feeling like he did something wrong? And you're leaning towards conviction? Mr. David, kind of shake your head.
You know, I mean, as I say, you know, I guess officers are people too, so they can make mistakes, but you know, generally we hire them and trust them to you know, catch people that commit crimes. So to that extent, you know, I guess I could have my mind changed, but it's, you know, we have to hear all the evidence. But it seems like he wouldn't be here unless something had happened.
Okay.
And maybe, you know, the officer misunderstood or made a mistake, but kind of generally trust that they don't make mistakes.
Okay. And I saw also on your jury card that there was a member of your family who was in the police force. Is that correct? And who was that?
My brother.
Your brother? Is he currently a member of the
Yeah, he's a highway patrolman.
highway patrolman? Okay. Does the fact that your brother is a police officer, and I assume you know about his job and here's some mistakes and all, is that going to influence your ability to weigh the credibility of a police officer's testimony?
You know, my brother's told me there's good and bad officers on the force, and you know, I think he's a pretty good one, but you know, he tell me that sometimes there are some problems, and you know, they you know, as I say, you know, I grew up with him, so I know that he makes mistakes sometimes, and you know, I know he tries to be real careful in his work, but you know, we can all make mistakes, I guess.
Okay. But I was thinking, I was hearing you say before that, you know, we hire these police officers, they're trained, we trust them to do their job right. Is the mere fact that an individual is a police officer going to make you believe their testimony over someone, say, who's not a police officer?
I mean, you know, I don't think just the fact that they're a police officer. You kind of have to find out more about what kind of person the officer was too, before you know whether they were believable.
Okay. So if we have a police officer sitting up here on the stand telling you what went on the night Mr. Alvarez was arrested, do you feel you're going to be able to weigh his credibility fairly?
I guess so.
Aside from the fact that he's wearing a uniform?
I guess so.
Is there anyone else here who feels that they might give a little bit more credibility to a police officer just because they are wearing a uniform? Mr. Berg?
No, not really.
Mrs. Ford?
I don't think so.
Mr. Bergson?
More credibility than him.
Then someone like you and me. I'm just saying generally if you get a police officer on the stand and then the next witness that gets up is not a police officer, it's just a citizen like you and me. Okay, so you're going to be able to look at each witness and just weigh the credibility based on their testimony and not what uniform they're wearing. Okay. Now, Mr. Lipscombe talked about the burden of proof being on the state a little bit. I'm going to talk some more about that. The state does carry the burden of proof in this trial, and they carry that burden of proof. They have to prove each and every element of a driving while intoxicated beyond a reasonable doubt. They have to prove identity, date, driving, intoxication. Each one of those elements beyond a reasonable doubt. And he did explain that beyond a reasonable doubt is a doubt that would cause a reasonable person to hesitate in the most important of their own affairs. And it is a very high burden. He explained that in a civil trial, the burden of proof is preponderance of the evidence. One side's just a little bit more or greater evidence than the other. It's kind of like 51-yard line on a football field. Beyond a reasonable doubt, being way down here, is at the other end of the football field. Ms. Ford, can you think of any reason why the burden of proof would be so much greater in a criminal case as opposed to a civil case?
Because in a criminal case, somebody could go to jail. In a civil case, you're just pretty much talking about money.
That's exactly right. That's exactly right. And wouldn't you agree, Mr. Bird, that someone's liberty, their freedom, is much more important than money or property or possessions?
Yeah.
So would you agree with the law that, would you agree with the reason behind the state having such a high burden of proof? Not that you can change it, it's the way it is, but are you going to be able to hold the state to its burden of proof in this case?
I think so. I mean, I guess sometimes I think it's a little extreme. That, you know, I mean, that maybe it was more appropriate when there are British troops snatching people out of their houses, but, you know, we don't have to worry about that now.
But we're still kind of stuck with it, right?
Yeah.
So, I mean, you would maybe like to see that burden reduced a little bit.
Yeah, I think that.
Okay. Is there anyone else who feels the way Mr. Bird does? Mr. Daly?
I mean, you know, if a person's done something wrong and the state, you know, gathers all the evidence, they ought to be able to meet that burden, I guess.
Okay.
It shouldn't be, you know, if a person did it, it shouldn't be too hard to show beyond a reasonable doubt that they
Okay.
did it.
But you will require the state to meet that burden beyond reasonable doubt? Yeah. Are you going to require the state to meet that burden, or is close enough all right with you?
No, if that's what the law says, then
So-
not one to change it.
Okay, so even though you're not going to agree with it, you would be able to follow the law?
Yeah.
Okay. Ms. Moore, you going to be able to follow that beyond reasonable doubt, Mr. Brooks?
Yeah, I mean, if he's guilty, make him prove he's guilty.
Okay. Mr. Daly, I'm going to pick on you a little bit. We were talking, Mr. Lipscombe was talking about intoxicated people or drunk people, and he didn't seem to have much experience with that. I'm wondering, are you a non-drinker yourself?
I don't drink
You
that.
don't drink, okay. And if I get too personal, you can stop me, but is it for religious reasons or?
Largely, yes.
Okay. Do you feel that no one should drink?
Well, I mean, it's, one of the things we're supposed to do is, people is, you know, try and keep control over ourselves and our lives, and when people start drinking, they're not in control of themselves, so, you know, on the whole, I think it's a mistake for people to drink.
Okay. Yeah, I mean, it's obviously a personal choice for you, but if prohibition were to come around again, is that something you'd be in favor of?
I'd probably vote for it, yes.
Based on your feelings about drinking, are those feelings going to get in the way of you being a fair and impartial juror on a DWI case? Because obviously, there's going to be drinking involved in this case.
Well, I mean, there's, you know, all kinds of things. Adultery is a sin that not always against the law, so I guess there's a difference between, you know, what I believe and what other people believe, and I do think it probably is a sin to drink, but it's, the law lets people do it, so.
Okay. But, and there's nothing wrong with it, it's just something we need to know. Are your personal views about drinking, and then just kind of your gut feeling about the whole thing, is that going to get in the way of your being a fair juror? Because the judge needs to know it, and Mr. Alvarez needs to know that.
You know, I've never been on jury before. I don't know that I could say until it's obviously put to the test and trying to decide. I don't really know.
So you're not sure that you should be a fair and impartial juror on a drinking case, a DWI case?
Yeah, I think I could be. I mean, I'd like to think that keep an open mind about things, and I know the law, as I say, the law doesn't say the same things as my beliefs, but, you know, I try to work to change the law, but for right now, it's the way it is.
Right. Is there anyone else here who does not drink? You don't drink, Mr. Rosen? Okay. And again, if I get too personal, you can stop me, but are your reasons religious, or are they other? Are you a alcoholic, or?
No, I just, you know, my mama didn't drink, but my dad used to drink a lot, so I just didn't like what I saw.
So you grew up seeing an abuser of alcohol, and you've just chosen to go away from that?
Yeah.
Okay. And once again, based on your feelings about drinking, do you think that's going to inhibit you from being a fair and impartial jury in a driving while intoxicated case?
I don't think so.
So you're going to be able to put your personal views aside and just listen to the facts and follow the law?
Yeah, I should try.
Is anyone here a member of MAD? Mothers Against Drunk Driving? SAD? Students Against Drunk Driving? Okay. Any other organizations like that that are trying to toughen the DWI laws or? No, okay. I talked to Mr. Daly about police officers testifying. I talked with you about it too, didn't I? Okay. So everyone here is going to be able to look at each individual witness and test their credibility based on their testimony and not on what kind of clothes they're wearing or what organizations they belong to. Is that right? Okay. Okay. Ms. Ford, you were talking about seeing potential drug drivers on the road. And what were some of those qualities of the driving?
Of the driving? Well, it's not so much a matter of people drinking and driving, because my husband and I both drink. We're both responsible people. But people who tend to be, especially I notice the problem with, no offense, but with younger people who tend to be a little bit more reckless just in general. And then when they drink, they drive fast as it is, they drive faster, they tend to take more risks, they take more risks. They tend just not to have a maturity level. And then in combination with the alcohol,
Right.
they're a lot more irresponsible.
So basically, they kind of lose their control. Let's hypothetically say there was an individual pulled over for driving while intoxicated, but he was doing maybe 5 miles over the speed limit. Hadn't done any, wasn't weaving, stopped when he was supposed to, put on his turn indicator when he was supposed to. Would you, as a normal citizen, seeing that, would you suspect that person of being DWI, driving while intoxicated? Okay. Mr. Burleson, what would you expect someone to drive like if they were intoxicated?
I would probably go all over the road. I mean, I've seen drunk people drive before.
I think we've all seen it. On I-35, everywhere else. So you would expect to see the typical weaving, not being able to stay in the lane, maybe rolling through stop signs. I've seen people stop at green lights. Have you guys seen that? That always scares me. What kind of driving would you expect?
Weaving and I think they go too slow.
Yeah.
They slow down.
You're waiting for them to get out of the way.
Yeah,
so you can-
or they'll stop or flashing red light and wait for it to change green.
They're going to be there till 6 in the morning, right?
Yeah.
Okay. Does anyone here speak a second language? Spanish?
Yeah,
Okay. Fluent?
more or less.
Okay. Let's say you're down in Mexico and you get pulled over by the police, scaring them, and they're speaking to you in Spanish. Okay. How would you feel competent to understand what's going on if they were explaining to you rights and what you're charged with?
Depends. I mean, they could start speaking slang and I wouldn't know what they were saying.
Right.
If I would more or less understand.
Okay. Coupled with the fact that you're probably under arrest and nervous,
Yeah.
might there be a problem? Not
Yeah.
understanding exactly everything that's going on.
Oh, yeah.
Okay. Anyone else speak another language? No? Someone had said that they were a witness to a case.
Why don't we go ahead, since we're running a little short on time, and stop it there, because I want y'all to have time to answer questions of the
Thank you.
students. Michelle, why don't you go ahead and kind of tell everybody what it is you like to do in Voir, what it is you're seeking to accomplish, and how you approach it,
Okay.
reach those goals.
Sure. My main goal in Voir is to get them talking. It's been my experience, and no offense to Mr. Lipscombe here, but the state gets up, and they kind of do a lot of talking. They give a big speech, and it's good because by the time the defense lawyer gets to the panel, they've already learned a lot about the law and presumption of innocence and beyond reasonable doubt, burden of proof on mistake, so that I get the opportunity to get up and get them talking. Because what everybody wants to know is the panel's feelings. I mean, we don't want any time bombs sitting out on our jury while we're in the middle of a trial. So I try and talk as little bit and let them talk as much as possible. In the DWI case, I want to obviously know if anyone's a member of SAG, MAG, if there are non-drinkers, if someone on the panel like Mr. Bailey who doesn't drink and doesn't think anyone should drink and would be all in favor of prohibition if it came out again. You need to know about these things. And oftentimes when someone like that starts talking about it, it'll get other people you'll see other people on the panel kind of nodding and going along with it, and then you can kind of nail them down too. In my opinion, that would be a challenge for cause. Because if you have someone who doesn't think anyone should be drinking, they're not going to be a very clear juror when it comes to a DWI case. Any other case is going to be fact specific, but I always want to, and then I always want to basically get into the specific facts of my case. Like in this example case that y'all have, there might have been a language problem. The guy was a Spanish speaker. He did speak English, but there might be a problem with that. So I kind of put those things in the juror's mind before the trial even starts to think of, hey, English was his second language, and maybe he wasn't understanding everything, and he was nervous, and so you go ahead. I thought you weren't supposed to do that. Well, you're not supposed to talk about specific facts of your case, but you can do anything you want through hypotheticals, and if you get out of line, you can be sure the prosecutor's going to stand up and object. I also wanted to bring out specifically in this case about the driving. I mean, the driving was good in this case. He just was going 10 miles over the speed limit. He stopped over the white line. Doesn't everyone do that? But he did stop when he was supposed to. And so basically, I'm also planting that in their minds that, he had good driving. He hadn't lost the normal use of his mental faculties. So, like I said, basically I try and bring all of that stuff out because that's stuff that you want to know. I mean, you might think you don't want to hear about it, but you want to know that because if you don't know it, one of those people can end up on your jury panel, which is going to be detrimental. And then I try and kind of plant ideas and theories of my case in their minds before the trial even starts.
The state has the first opportunity to voir dire, and it's the most important time because in the first 2 minutes, the jury's going to decide whether or not they like you. Half the jurors are going to come in there believing the defendant's probably guilty of something. And that's a fact. Regardless of how many times you tell them the presumption of innocence, that's still going to be there. He was charged, he was stopped, there's something going on. And so what you have to do, or what I like to do first off, is I want to get to know him very briefly. I want to put myself forward as being someone who's not going to hide the ball from him, someone who's going to present the evidence, even some of the evidence that may not look so good for us. Okay? Once I establish that, I want to introduce them to what the law is. I want to find out particularly what they know about the law, and if they disagree or agree with the general concept of whatever law is that's covered with the offense. You'd be surprised sometimes what people will tell you. But that's why you do voir dire, so you won't be surprised later on. The third thing I want to do is I want to steal the defense's thunder if at all possible. I want to be the first one to tell them about the burden of proof. I want to be the first one to tell the panel about the defendant's rights. I want to be the first one to say that he has the right to remain silent, and by golly, I hold that right to be dear. Okay? Part of it's theater, of course. All right? But you want to do that. And I personally believe in the defendant's rights and his right to remain silent, so that's not hard. But you want to do that. If you don't mention them at all as a prosecutor, then when the defendant gets up and goes into this, the defense attorney can go up and make it kind of sound like you're trying to hide the ball from them. So I want to get it out. I want to do things visually so they can see them. I'll have a chart or put something up on the board as far as the elements of the offense, just so they can visualize that. All during trial, you want to focus someone's attention on pictures, on graphs, on charts, because people's attention is held there. During your final argument, you want to make lists. The last thing they know going back in the jury room is, these are the lists, this is why this side wins. I want to establish the parameters of the case. I want to find out, in this case, an extremely weak state's case in a lot of respects. I want to establish just what people think might be outrageous police conduct versus, well, it's okay to stop someone for a traffic violation and then you think there might be a problem here, so it's okay to do further investigation, you'd rather do that than have the cop throw them in the clink right away. You know, get someone, this is what I would do, would be to develop that. And how do you do that? You do field sobriety test. And so I bring them in to show them what field sobriety tests are. And has anyone ever done them? You know, what do you think about this? Wouldn't you agree that, you know, a normal person, if they didn't have a medical problem, could probably do those? You know, and you're going to get most people, if they like you, if you've gotten them agreeing with you so far, they're going to agree with that. And once you start having the people agree with you, whichever side you're on, it's going to be a big benefit to you, okay? If I see that a person has a brother or a relative or someone that's a cop, it's just my personal quirk. I don't usually question about that. I let the defense bring that up, okay? I don't, if I see something that I might like, I won't necessarily bring it out. I might let the defense do that. I will sneak in as many facts as I can. You can do hypotheticals, you can get a lot of your case in if you do it in a smart way. And you really need to. On the defense side, it's your client. They're paying you or you're retained, and you owe it to try to get as many facts in so that you can ask the jury questions. And in doing so, I think there was a question up there, one of the jury panel members said, well, you know, why do you think he might be guilty? Well, that man over there, meaning me, said that he'd been stopped by the cops. This is a perfect time for the defense to turn around and go, but ladies and gentlemen, that's just it. The judge will inform you that what he says, what that prosecutor says, is not it. And that can also have an impact, because that's one of the things that I forgot to say in my voir dire meeting. What the defense may also do is pick out some of those things that you always say, you can never remember everything unless you write everything down. I don't like to do that. And you can pick that out and use it against the prosecutor. I like to emphasize my weaknesses in my case. I like to emphasize them to the point that I can weed out those jurors that I might not like. All right? If I have someone and I've discovered that they don't like police officers, then I'll work on that person. I'll come back to them. And I might even try to agitate them just a little bit in the form of a question so that I can get them to the point where I can challenge them for cause. That's basically my philosophy. I want to set it out there. Some people might call it a shotgun approach. I try to do it so that I have as many factors, as many facts about the individual as I can. I am not good with memorizing names. You know, I tried doing that even just with 6 of them. Sometimes you can get messed up. Okay. I'm good with faces. I don't try to memorize names anymore. Some people have the faculty for that, and for some reason I've lost the normal use of that thing. So I'll shut up right there and I'll turn it over to you.
Anybody have questions? Yeah.
The Joe comment, do you think that could hurt you if they if they love Governor Bush or something?
Yeah, in a real trial, I probably wouldn't have done it. I almost said it would be a Republican that would kick a working man down so he couldn't get ahead. But
Democrat.
see, I'm a Democrat, and you can be a Democrat prosecutor in Travis County. Have a Dallas, that wouldn't work. Yeah, you got to watch out what you do. What I really try to do is I will make some sort of comment which makes fun of myself. You know, of course, that's not hard to do. But you do that if you get the jury thinking, hey, this guy can laugh at himself, or this woman can laugh at herself. And you talk about their day, you say whatever feels comfortable. Sometimes you don't know until you get up there. But you make them laugh, you've got to break the ice.
I think it's a matter of just trying to be personable and not be a lawyer. You know, just get down and talk with people. And usually the state starts off talking about how this is like your only chance to talk, so you better do it now because you're going to hear us yapping for the rest of the trial. But I think it is just to talk with them, be yourself, and just get to know them, because that's, you need to know who those people are.
You asked a question, which is Whitney, about religion. I thought that was kind of a no-no. So you couldn't ask questions about their religion or anything like that.
Oh, about the non-drinking?
Yeah.
Yeah, that's why I kind of prefaced it with stop me if I'm getting too personal. But I typically want to know, because a lot of times, in the non-drinking case, there'll be reformed alcoholics, and then there'll be a lot of others who raise their hands, and it brings out that fact in a lot of other people.
The Travis County Jury Information Cards still have
Yeah.
information lines about what your religion is.
Yeah, their religions are on these.
Yeah, I have seen some pretty hostile answers on that. This is none of your business. But most people will answer.
Which is information itself.
Yeah, exactly. It lets you know you don't question the religion.
I had a Zen Buddhist one time, boy, did I want him. He was struck.
I struck as in. I wasn't charged.
One of the things I noticed was that you would go through and question every single person and have them answer the same type question or a very similar one that was exactly the same. If you had a large panel, would you still do that? Or?
If the question is important enough, and I think what I was questioning him on was drinking. Anyway, if it's real important, yes, I will. I will, because a lot of times when you do that, does everyone else feel that way, or I take it by your silence that a lot of people aren't going to be forthright with that, with their answer. And so if it's really important to me in my case, I will question everyone. And in like felony panels, when you've got looking at 50 people, you might do it like row by row. Anyone in the second row have a different thing than third row, anything like that. But I will. Usually I want more than 20 minutes.
There's some questions over there.
Yeah, I had a trial ad class, and y'all may know Robert Hirschhorn and Kathy Bennett, but his big strategy was, first of all, you tell them that there are no right or wrong answers, and then his big thing, other than that, was what you were doing is get a question and then what do you think about that, and what do you think about that, and I guess that's, I don't know if that's a specific strategy of yours.
Well, again, like I said, I really want you guys to talk. I want to talk as little as possible. So I want you to respond what he's saying, and then for her to respond what you said. And it seems to be a lot easier for the jury panel to talk if they feel more like they're talking with each other and backing each other up, as opposed to just being like, what do you think about that, and being put on the spot. So, I mean, that's just a personal strategy.
And there are some studies out there that show that jurors don't listen to lawyers during court hour, but they listen to other jurors. They'll listen to people in their peer group. They were done with exit polls of people who actually served on juries.
Yeah.
Through a whole bunch of questions, and that was one of them. And that really is one of the things that has given rise to this method of questioning, where you don't answer the question, but you go to somebody else. And I mean, you can take almost any topic, and if you understand the process that's going on, that is, keep them talking and you sort of back away from it, you can get a jury panel, members of the jury panel, to define all the elements of self-defense. And once they define it, they'll believe it. But they don't have any reason to trust you. You're an advocate, you've got a stake in this case, you're a lawyer, they don't like lawyers to begin with, there's all sorts of things wrong with you. It's the very first thing that happens in the trial, so it's awful early for hard advocacy. But if they're talking to each other and saying, well, I think this, well, now that little part of what you just said was wrong, but I think this part is right, and that sort of a discussion, they're learning, they're listening. And time after time, that seems to be exactly right.
Obviously, with drinking is sin and being having a brother as a highway patrolman, I wouldn't be too attracted to the defense side. But at the same time, within that span, I worked as hard as I could to make myself at least mildly attractive. Have you ever, do either of you see witnesses that maybe in their own beliefs are completely against what you want to do in the end, but you think that you might make them feel, self-conscious enough about those that they'll almost go too far in trying to not think of their own beliefs? And
Well, I'm sure John has had the same experience, but nobody wants to say, no, I cannot be fair and impartial. I'm absolutely biased. So it's real, but that's what we need for y'all to say in order to get you challenged for cause. And so that's why I kept like hounding you to say, but you wouldn't give me a positive answer. So everyone says like what you did. I mean, you're exactly what, well, I think I can. I'll try. Even though I absolutely hate drinking and think everyone who drinks should be shot, I think I can be fair in this case. So I would challenge you for cause.
She'd strike you.
Yeah. If I didn't get you for cause, I'd strike you. But
I mean, at some point I realized, boy, I'm just not going to be on this jury anymore. But, I mean, I was wondering, do you ever find people that you can sort of get them to where they think about it enough that they might say, well, oh no, it's just my bias kicking in, I'm supposed to not have bias.
Yeah, you have people all the
And
time.
they'll go all the way to the other side.
Don't
Can
say
you pick those?
Yeah.
Yeah. They say they went back to the jury room and they felt so bad about it, they were giving someone the benefit of the doubt. That's what hangs that jury sometimes. You guys got to be very careful about stereotyping jurors. It's the way juries were always picked up until 10 or 15 years ago. And it's still a strong lure for lawyers. I mean, when we sit down and pick juries, we still say, well, you know, this woman's husband's a cop, and da-da-da-da, and so forth and so on. And, you know, sometimes having police relationships for a defense lawyer, depending on the case, may be the best thing that you can have, because they know that all the dirty cops. And they know that cops lie. And they know that their husbands come home and arrested somebody because they didn't pass the aptitude test. And they know all that stuff. And they can be the best, you know, but you have this innate fear of them, and yet they may be the best thing that you can do for the jury, for your client.
Yeah, my ideas when looking at the jurors on paper are always very different from after I get a chance to talk with them. On the sexual assault of child case David was telling you about, there was a woman at the very beginning of my panel who had previously worked for the Center for Battered Women and was currently working for Pebble Project, which is a project that helps abused kids. And I saw her on paper, I was like, she is so gone. And I ended up keeping her on my panel after talking to her because she brought all this out in the jury about how, oh yeah, I've seen it all. I have seen the false accusations. I've seen how it ruins families' lives, and on and on and on. And that was basically the theory of my case. And so you really have to listen to the people and not necessarily think because they're Baptist they're going to be a bad person on the jury.
Clarence Zero did say that if there's anything worse than a Lutheran on the jury, it is a Baptist.
Depends on your side of the case. Yeah, we need to close, but it's interesting that Michelle said that she was looking, this juror fit the theory of her case. We talked about last week, you've got to decide what it is you're trying to get out of jury, your juror profile, what you're looking for. It may have been a different case, that very same juror. Even if the charge was the same, you may have had a very different defensive theory in another sexual assault case, and that very same juror may have been one she wouldn't have taken. But she was ready, knowing what her theory of the case was, what she was going for, and what kind of juror she had to have to fit that theory of the case. And that's the secret sauce. You can't go into it and treat every voir dire the same and say, well, here's a trial over here and here's a voir dire here. They're separate things. I'll do the voir dire and then we'll get into our defensive theory and our trial strategy. The trial strategy is blended into the whole voir dire, is implementing your trial strategy. And you see too many lawyers, I think, that just think there's voir dire and then there's the trial with strategy. You know, picking a jury is one thing and the trial is something else, and they're not. It is the most important part of your trial strategy. I think we need to shut down. It's 5:30. Thank y'all both very much.
It's